If you have not sat through one of these seminars, you are in for a real treat and probably a little scariness, because I've sat in these many times and I learn something new every time I come. And I always see restaurateurs saying, "Oh, but this is okay, isn't it?" No, usually it's not. But we've got a team of experts here that'll walk you through all of that, and we'll be here to answer lots of questions for you. So the session that you're in for right now is to talk about labor and employment. And I'm sorry I didn't introduce myself. My name is Sonia Riggs. I'm the president and CEO of the Colorado Restaurant Association. We are really grateful for you taking the time to be here today in this presentation and at the show overall. Just a note of housekeeping. Everyone here who purchased an education pass will also get a video recording of all 3 sessions and the slides that go with them. And you can expect that by early next week. Before we get started, it is my pleasure to introduce Maggie Dankenbring from Toast. They are the generous sponsor of this session, and she's here to introduce our speaker and tell you a little bit more about Toast and how it can help your business. Maggie? Thanks so much for being here. We appreciate it. Yeah.
All right. I recognize a few faces in the room. I'm going to start by taking a quick poll. Can I get a raise of hands for all of the restaurant owners in the room who have had to bus a table or take an order in the last few months? All right. I know none of you opened a restaurant, a cafe, a bar, or a brewery just to end up working every shift. I also know that with labor costs rising, this is a reality. I'm Maggie. I'm from Toast, and I'm your local Denver account executive. We work with restaurants like yours every day to help lower costs, boost efficiency, and keep you profitable. Labor costs aren't just climbing. They're cutting into your margins faster than a no-call, no-show on a Saturday. Minimum wages are up, and let's face it, your best server just left, probably to sell real estate. But we're seeing that the best operators aren't just surviving, they're adapting. Take the team at Stoney's Bar and Grill. He, like everyone else in this room, was feeling the squeeze. He got smart. He transitioned to Toast. He equipped his servers and bartenders with handheld devices, added kitchen display screens, and he increased his revenue by 20% overnight. And he cut back on labor. But here's the kicker. The guest experience actually improved. For bars or breweries without a kitchen, take Haters, Trax Nightclub, or Retro Room, for example. By equipping their bartenders with handhelds, their staff no longer manually enters tips at the end of every shift, going through each of those paper receipts. Their staff leaves early, saving thousands every month. If you want to strategize on how your unique business can offset rising labor costs, come on over, talk to us at our booth. Maybe you're a coffee shop or a cafe owner, wondering how you can drive up guest foot traffic or diversify revenue. Maybe you're a brewery experiencing the drop in guest foot traffic. We've got booth 301 set up, and we're raffling off gift cards because, hey, if you're going to deal with labor costs, you might as well get a free dinner out of it. Swing by booth 301, say hello. Let's talk about how we can take back control of your labor costs. If you want to book a demo with us, feel free to scan the QR code as well. But now it's my pleasure to introduce the CRA's primary legal resource center partner, Micah Dawson, who is also a partner in the Fisher Phillips Denver office. Through the Legal Resource Center, Micah and other attorneys give free limited legal advice to CRA members every month. Micah is an expert on wage and hour laws, has years of litigation experience, and has successfully represented employers in various discrimination, retaliation, and whistleblowing matters. Even better, Micah is a native who grew up on the Western Slope. Without further ado, please welcome Micah. He has a wealth of information to share with you today, so let's let him get to it. Thank you.
Where's the clicker? Is this it? Awesome. Thank you all for joining today. I am joined here by my colleague, Hillary Ross, who's also in our Fisher Phillips Denver office. We're excited to be here. A lot of you probably historically have seen Todd up here. I can tell you I did all his slides for all those presentations. So I know exactly what he told you. But Todd has transitioned into retirement and is off in Europe biking somewhere. But in the meantime, in knowing he was retiring, we have built a restaurant team at Fisher Phillips. Hillary's a member of it. We have a couple other members. All of us have very specific experience in the restaurant industry. And more importantly, both Hillary and I have experience in the restaurant industry in California. We're both Colorado natives, but for some reason litigated in California and dealt with all of the issues that have seemed to transition here to Colorado in the last couple of years. So hopefully through this, you'll be able to put some tools in your tool belt to help out. We'll take questions kind of section by section as we go through, but happy to help. There we go. So why are we here? Obviously, as talked about, your labor costs are exploding, especially within Denver. Along with that, the state level agencies and the state legislature have made it harder and harder for you to operate a business. In addition to that, there's been a 300% increase in class action lawsuits against restaurants in the last 5 years. What I mean by that is in 2019, there were 2 or 3 class action wage and hour lawsuits. Those lawsuits are where one individual person says, hey, I missed breaks, hey, I didn't get paid overtime or tips, and they make a class of everybody who's worked for you in the last 3 or 6 years. Now, currently, there's over 100 pending in state court, just against restaurants alone. So they've started in the QSR industry and they're starting to move more to the brick and mortars into the individually owned. And how they're doing this, unfortunately, is the action groups that you see and the progressive groups that are taking on these lawsuits against Amazon, Aspen Ski Co. are doing that on a pro bono basis. The plaintiff's bar is going after Colorado-owned entities and suing them in state court to avoid federal court review. And as you'll see later in the slides, the numbers that they talk about as the exposure levels for these will scare you. So, something went wrong with that one. First topic, tip credit. Obviously, this has changed in the last year. Previously, Colorado was in line with federal law, where an employer just regularly had to be engaged in an occupation that received tips and received $30 per month. Very low threshold, pretty clear standard in terms of making determinations. Now, as of last year, the Colorado Department of Labor has redefined a tipped employee to be any employee who receives more than $1.64 per hour, which is still, for servers, easier to reach. For bussers and your server assistants, they are attempting to create a line in between those individuals being able to receive a tip credit. So that's a very specific math equation as to, can I have a busser at a tip credit wage? Are they actually receiving $1.64 directly per hour? And it will make you reevaluate, can we include server assistants, bussers, et cetera, barbacks in a tip pool? Can we pay them the tip credit at all? In terms of workers who don't do enough to qualify for the tip credit, you obviously have to pay the full minimum wage, whether it be Denver, Colorado, or otherwise. There we go. We can still require employees to tip pool. You can't have a tip pool where some of the employees in the tip pool are receiving a tip minimum wage and some employees are receiving a full minimum wage. That's an invalid tip pool up front. In terms of the employees who have significant customer service interactions, it still has servers, bussers, counter personnel, sushi and teppanyaki chefs. If your bussers are having direct interaction, if your barbacks still do have interactions, take stuff off the bar, have guest interactions, they still can fall into this caveat and still fall into a tip credit employee bucket. It's just you have to make sure that their actual experience is meeting that standard. You can't have barbacks who never turn around and only have their front facing to the bar receive a tip credit. The other open issues, expo and food runners. Are they only doing expo? Are they only dropping off? Are they having enough direct customer interaction to justify the tip credit? In those circumstances, if they're cleaning tables, if they're delivering food, if they're running back changes, you may have a strong argument. If it's literally just if it's a 2-person expo, 1 to the server, that's probably not guest interaction that can claim tip credit. The 80-20 rule, a lot of you historically have probably seen this go back and forth with federal regulations. it is still, while it has been rolled back federally, it is still the interpretation of the Colorado Department of Labor that applies to Colorado law, unfortunately. So in that circumstance, employers can use a tip credit only if an employee is 80% of their work is tip generating. So in these circumstances, you're looking at, again, barbacks is 80% of their job, tip level work, but also this includes some of your senior leads, your lead bartenders, your lead servers, who may be doing scheduling, who may be doing some accounting work, who may be doing some back of the house. If that back of the house time is more than 20% or more than half an hour specifically, you may be putting your tip credit in jeopardy. To the extent you're able to track those hours for those specific individuals who have kind of dual role jobs, it's very important to track what time they're putting in administratively compared to what time they're putting in as a server, as bartender, etc. That way, if you're ever audited by the Colorado Department of Labor, which we'll get to, you have a justifiable basis to say, yes, they do perform some tasks, but it's never over half an hour and it's never 20%. The best defense on this is an attestation by these employees or an acknowledgement in their job description, having them review and sign it where it explicitly states you're only doing 15% administration work or 15% scheduling, and I'm never doing it over half an hour. That's another layer of defense that you can put in place for these gray area employees that I know you all have who are performing multiple functions, probably yourselves, probably your number ones or number twos in smaller establishments. That's where if you need them to be a tip credit employee, you need to be tracking this type of time. The tip pool. I did a quick review. Our free legal resource center has received over 400 tip pool calls in the last 2 years, which is a great thing. Those 10-minute calls save you thousands of dollars and hundreds of hours after the fact. If you call beforehand, before an audit, before a lawsuit, before a demand letter, those free calls, or even if the call goes over to the extent we have to review a policy or come up with a new handbook or new tip pool policy, those are extremely important. We welcome those. Those 15-minute free calls are great because in that 15 minutes, we can tell you usually yes, no, ooh, what do we do, and let us review. But in terms of tip pools, keep calling. If you have questions, the rules don't make sense at this point. There's 4 different rules. They change every 3 months. Making sure you're in line with the current interpretations of the Colorado Department of Labor, which I guarantee will change by this summer, is important. So, easy actions to take. Managers can never be in a tip pool. Hillary and I were joking. There's a new age title issue where we see it a lot more in corporate America, where everyone's named a manager, account executive, assistant manager, all types of titles, bar manager, bartender. These titles, while they may be important, preclude them from being in a tip pool at all. So if you have senior bartenders or lead bartenders, use that title. Don't call them bar manager if they're not actually managing, if they're not making decisions for you as an employer. It is helpful if they're a senior bartender, easy in a tip pool. There's no argument. If it's the same person named a bar manager, I can guarantee you we're going to lose a tip pool question and a tip pool audit. There's nothing I can argue to convince a judge or a ALJ that someone with the title manager isn't managing if you call them that. So the issue is almost self-created. If you're having employees who aren't truly managers or don't truly have managerial capacity, having that title and being in tip pools. Implement a clear policy. If your tip pool policy is not written, if the calculations on how it gets distributed are not written, you're already coming from behind. It has to be written. It doesn't technically have to be signed. If you have employees sign it when you change it, it's helpful if you get everybody to sign it. But as long as you have it written policy, it's been distributed. I talked to 4 employers this week where we're posting it because we're doing changes as we head into the spring for some of the seasonal employers in the mountains. But it's important to have it written. It's important that they know. Because, as you know, sometimes tip pools change seasonally or with respect to different times. Making sure employees know and it's written. If you get audited, that's the first piece of paper I want. Train your management. I'm hoping in today's world you don't have managers trying to dip in, but it happens all the time. They see Generally, your servers make more than your managers. I can tell you in a lot of restaurant operations, it's almost impossible to promote to a GM level if you have servers making tips at a high level. A lot of smaller restaurants, the tip employees make twice as much as your managers at times, depending. There are some restaurants in here or at the show that their servers make six figures, where managers or GMs are at a set salary. So in those circumstances, making sure your managers aren't kind of dipping in or saying, hey, I should have a piece of that, even if your tip pool doesn't allow it. It's important. We have seen an uptick in this in the last year, unfortunately. I think it's because of the raise in the tip credit wages, the amount of tips coming in, and the salary levels that are being set in Colorado. We have unfortunately seen more managers dipping into tip pools and the issues those create because of kind of the disparity between their manager level salary and what their report level employees are making. Give notice to customers. If I could put this on a giant banner across the show, I would. It's the stupidest law we have, and it's the easiest to screw up. There are members of CRA, there are other restaurants in the state that have lost millions of dollars where their tip pool's perfect and they don't have a notice on the receipt. And as archaic and as silly as that sounds, unfortunately, that's the law in Colorado for some reason. So if you don't have just the very specific CRA language that I believe is on the website in the center, it's one sentence. It's from the state. It basically just says we pool tips. Make sure that's on your posters, on your tabletops, or on your receipts somewhere, because that's the easiest way to lose a tip pool question, even if you're doing everything else perfectly. Questions before we move to breaks?
All right. You have a question?
I do.
You do? Okay. We'll come with you.
So, quick question in regards to QSRs versus full service restaurants when it comes to managers and managers who are kind of doing a lot of the back end duties and they're jumping in and helping out. How does that change for the tip pool? Does that affect it at all, or?
So if they're, I'm assuming those, at the QSRs, there isn't a tip pool, or is there?
We don't right now. We do get tips, but yeah, that's.
Then if there is not a tip pool or a tip pool including tip credit employees, it doesn't matter. That only impacts the manager taking part is if they're taking a tip credit on that employee. So if you're paying full minimum wage, as long as their title is a manager, you can still include that person in a tip team.
Okay, got it. Thank you.
Are you allowed to have Are you allowed to have a manager that clocks out and clocks in as a different role and be involved in a tip pool?
It depends on the call. Let's have that one is a very fact specific circumstance. It depends on the employee, their primary position, and how they're hovering. It can be, but it's very fact specific. Give me a call. Okay. I'm happy to discuss.
Can I just open that? But haven't you said on that issue, it's still really, really risky because if the employees, if you get sued, are going to testify that they know that person's a manager.
Yep. No. It's a rare circumstance that would be allowed. It would only be allowed generally in circumstances where you have a full-time manager and you don't have enough staff. This happens in the mountains, and it's very fact-specific agreements that you have to put in place. But there is a high level of exposure, again, if you have managers being in a tip pool.
Also, Micah, can you get a little closer to the mic because we're recording, and so I want to make sure that we can always hear you.
To piggyback that question there, okay, so let's say specifically you have a manager. You have a sommelier 5 nights a week. The 2 nights a week that the sommelier is off, the general manager, floor manager, whomever, somebody with a manager title, though, does all of the sommelier duties from start to finish, absent a position that's, the regular person is gone. It was my understanding that they could be in the pool because they're performing the duty of service. No, not with a manager title, not performing those duties, because in that circumstance, they're not the sommelier. They're still whatever their manager title is. And if you're paying
if there's a tip credit being taken on anybody, there's a high level of exposure. Even if they are all being paid full minimum wage and you're pooling, it's still a level of exposure because their title's still GM and they're in the pool.
So, okay, if a bartender calls out sick and you were only running one bartender that night and the GM steps in,
He can receive all. So here's the caveat. If they're receiving direct tips, the small EA is a little bit different because they're not the lead table. But if your GM has to jump into a bartender role and they get tips directly, they keep all those tips. Those tips can be carved out of the tip pool because it's a direct tip.
so patrons sitting at the bar who tip that person,
He keeps his cash.
but
anytime
they can't be tipped out by the servers for making service well drinks.
Yep. So they can't take part in that pool, but if they're getting direct tips for people they're serving, they can keep those individually because they're their own tips. And it's separate from a tip pool. And I can tell you, I've had more calls about that issue where GMs or managers jump into a hostess stand or they're running takeout. In those situations, again, they can receive all their direct tips and keep them. They just can never be part of the pool. That's the caveat. In terms of direct tips, you can keep, but you can't ever kick it in or take anything from other employees' pool.
Yeah, the issue is less about them receiving tips, and it's more about whether or not they're taking tips from other employees who are not managers.
Others. Okay, here's the fun part. Oh, do we have one more?
One more question.
So what if like you have like a bar where it's running 2 bartenders through the dinner rush and then the bartender clocks out and goes to a floor supervisor position, but they tip pool during that rush for the 3 hours that they're together, you know? How does that work?
What are they performing? It depends on what they're performing, the secondary role.
So, you know, like as the floor supervisor, once the managers leave or whatever, then they kind of are like a shift manager, but it's not titled that as a floor supervisor. So is that kind of the loophole?
If with that title, in that time period that they're a floor supervisor, if it's over half an hour, if it's more than 20%, they can't receive a tip credit during that time. And you probably put in jeopardy their bartender time. If it's a full tip or if it's a full minimum wage you're paying and they're in a tip pool, there's an argument they can be included, but it's fact specific. And I'd want to walk through the specifics with you because you could also clock them out at the end of the bar shift and pool.
Well,
there's a lot of different options in terms of kind of.
So he like clocks out as the bartender and clocks in as a supervisor, which has a higher wage and everything.
Is he receiving any tips or is he receiving any of the tips that are pulled during that floor supervisor time?
No. So we break it down like, so if he worked 5 to 8 with the other bartender, then he only gets the time percentage of those tips, you know, like the 3 hours or whatever.
That's going to be close. And if you only have 2 bartenders, I'd say don't pool it. Just do direct tips
Okay.
the whole time.
Oh,
But
cool.
yeah, happy to talk.
Thank you.
Right. Oh,
You were right. There are going to be a lot of questions
Okay.
about this.
I came in a little late, so you may have already addressed this, but if you have a tip pool that includes everybody, nobody has a managerial status, everybody's equal in that regard, except for the owner. And you have employees that do 80% of their work collecting, cashiering or whatever. 80% of their work is tip related, but you also divide up tips among the kitchen crew. That 80%er, do they get full minimum wage or do they get partial?
they have to have full minimum wage.
Okay, thank
As you're paying your kitchen staff full minimum wage, I will never allow a client to have a tip pool where there are tip minimum wage and full minimum wage employees included. It's the easiest way to get sued. Breaks. This is the bane of everyone's existence. How many of you are tracking employees or having employees clock in or clock out for 10-minute breaks? Oh, thank God you guys listen. The issue with that and what we've learned over time is that having employees clock in or have a policy where that says clock in for your 10-minute breaks. Given the age demographic of most of your employees and the generation that's coming up, they're not going to do that. And then if you get sued for a break lawsuit, if only 20% of people ever clocked in, you're then proving why the other 80% of the time they weren't doing it, or why were they actually receiving breaks. It is easier to have a very strong policy that authorizes and permits breaks and tracks it. You can have employees sign off at the end of the day that they were allowed or authorized and permitted to take breaks, but it's easier to have a policy that allows them or permits them to take them. If you have time for managers to schedule them or set them at specific times for employees, again, in this industry, it's very difficult. It's either because you have the pre-shift work, you have the pre-rush work, and then you have post. It's almost impossible for you to give a rest break during rush. So your scheduling is a lot more difficult than other industries, but making sure that you have a policy in place, or at least something for managers to follow about when breaks can be or authorized and go around and tap people, it's important. But to the extent you can avoid having them track it, unless you're able to either 100% have them clock in and out, or you're paying 10 minutes every time they don't clock in and clock out for rest breaks, the better option is having a strong policy with sign-offs that authorize and permit, and not tracking them specifically. Meal breaks, track. You have to, because they're not getting paid. But in terms of rest breaks, there's not a law that they have to punch in and punch out. So if you have this is the standard rest break policy that you see in our handbooks that we'll give to you. It's essentially from the state website and the definition, the caveat being the last sentence. You then put it on the employee to report if they missed it. So you're changing who the burden of proof in terms of who didn't get a break. Unfortunately, right now, the lawsuits that are being certified as class actions have this issue with employees only clocking 20, 30% of the time, and the employer has to prove, no, they were given the chance the whole time, they just might not have done it. I can tell you that's going to cost you $250,000 to argue, at least. And then, why does it matter? Let me get to the numbers. This is just a few of the settlements or findings that have occurred through rest break only class actions. These are only rest break numbers. All of these are Colorado-owned companies. And the numbers, this is the settlement number. This doesn't include the attorney's fees that you're paying just to get to this number. Most of them start, the 1.25 one, they started at 25 billion with the exposure level. And as you know, and as you'll learn with the new wage laws, if you owe someone for 10 minutes, that can be it can be multiplied by 3 or 4 times what you actually owe them under our new wage laws. So these 10-minute issues every day for each employee add up to millions of dollars. They essentially take the revenue from your entire operation for 3 years. Most of these entities, I can tell you, the restaurant, the 1.25 has 12 locations that make about $100,000 a year in revenue. That's an entire year of revenue for a company that they're paying out. They're essentially making the plaintiff's bar partners in their company for an entire year. Most of them have to take out loans to pay these, to get rid of them. But these are just some of the smaller numbers. We're dealing with a pizza one right now that I just got a demand for 38 million. So these are, and not, I mean, that's when you're 20, 30 stores, but our single store franchisees, or our single store Colorado owned restaurants, single brick and mortar, can still have $1 million in liability. Now I scared you. Child labor. Has anybody had a federal DOL audit in the last 2 years? Interesting. We have 5 going on for members right now. I know, sorry. No, we have 5 ongoing DOL investigations. The federal DOL has recently hired 5 investigators in Denver. They're young. They're going through their processes. They're checking their boxes. Child labor is the number one topic for DOL federal investigators. That's going to transition from administration to administration. It's easy to miss. We've had situations last year where you have, the younger brother showed up and covered his older brother's shift. That put him over 40 for the week. Or, hey, this kid worked too many hours for the week. Tracking your minors, making sure that Colorado has very lenient minor laws after you're 16. So just making sure you're not having minors work overtime is extremely important because the fines do go up really quick. It can be up to 20 grand for individual violations of child labor. That's why it's so important to them. So to the extent you have minors working for you, it's a great time to look at it now before you get an audit letter. Because I can tell you, we've seen the increase in DOL audits in the last 2 months has been significant compared to the last 4 years.
Do you want to take questions?
Oh, questions on those two?
Well, so with the child labor laws, is it just so they just can't work 40 hours, but like there's not like a curfew for them or anything?
You know, there's also restrictions on what sort of equipment they can use, things like knives or slicers, stoves. I believe on school days, there's only certain hours they can work. If you want to give me a call, I'm happy to look that up because I don't want to misrepresent not remembering it off the top of my head. But yes, there are other restrictions.
All right, cool. Thank you.
This one is a newer one probably for the group. Accommodation issues are something we're seeing across the board in all industries. Where they come up is having individuals who go out on all of our wonderful sick leaves, our family leaves that Colorado has, and then they're not able to come back. So if you have an employee who goes out on sick leave, runs out of sick leave and says, oh, I can't come back, a lot of employers will say, okay, well, it's a no call, no show and separate. Or if they're on family leave, same thing. Hey, I'm not ready to come back. They're not FMLA eligible. Okay, separate. That decision and not engaging in the interactive process or potentially identifying there could be a disability involved is a exposure level event for all employers. If you're separating employees at the point that they say, oh, I can't come back because of blank, my foot still hurts, I can't do this, I'm just not ready, I'm trying to think of the best one, I'm not mentally ready to come back, that may be a disability issue. Having your managers, the ones who are having these discussions generally in text with your employees about these issues, ensuring that they know, look, if an employee can't come back, we need to have a conversation. If it's an individual issue and if it's a health or a mental issue, in today's world, everything is a disability. Their dog's sick. I can tell you the state of Colorado will call it a disability. All of these issues, if they can't come back, need to at least have a discussion of, okay, are there any accommodations needed? You need to send them an ADA accommodation packet. And at that point, if they come back and say, no, I don't need any accommodations, I'm just not coming to work, then you may have that discussion. But if they're, hey, I'm not ready for the next couple months, or I need to recover a little more, that's a situation where you probably shouldn't fire her, because a reasonable accommodation is unpaid leave. So you can put them on unpaid leave. It's a reasonable accommodation all the time, and it's not job protected. So unlike family leave, unlike FMLA, you don't have to keep their position. You can fill their position while they're on unpaid leave, and when they come back, or when they're ready to come back, if they come back, because most of your employees can't go 3 months on unpaid leave without a job. At that point, you don't have to put them in their same position. You have to have a discussion to see if there's a role for them, but you're avoiding an exposure level event where you're terminating them without going through this process. It's hard to explain or pinpoint when it happens, but having your managers know anytime there's an employee who's not returning from sick leave or otherwise because of a physical or mental issue, HR or managers should have a discussion. What do you need to come back, or what would allow you to come back before making a termination decision? The number of lawsuits that come out of this single event, and it's hard to identify because employees are vague. Oh, I don't feel well still, text messages, don't tell you I have a disability. But if you have managers receiving those, that's a discussion point that needs to be pointed out to them, and they need to know, hey, I've got to raise this up to the owner, and we need to send the packet. The packet's easy, it puts all the onus on the employee, and I can tell you once you start making employees do things, as you know, they might not follow through, and it'll just give you additional layers of defense to avoid any of those lawsuits.
And I would say this really is one of the trickiest areas of compliance across industries that I see, because there are so many things that play into it. There's paid sick leave, there's family, there's FMLA, and then there's the potential accommodation issues. So the best thing I think you can do, sort of following on what Micah was saying, is to just see the red flag when someone's saying something, even if it's vague, and, get HR involved, get counsel involved if necessary, because, an ounce of prevention is really going to help you here.
This is the number 2 topic in CRA phone calls. And most of the time, they don't even know it. Most of the time, employers are calling to say, are they wanting a thumbs up on a termination? And they end up having to talk to us 2 or 3 times. The reasonable accommodation dance, or the interactive process dance for accommodations, I tell employers we're going to have 4 phone calls at least. Mm-hmm. It's a very slow moving dance, but it's going to help. So when you call into those, we may be able to give you immediate advice, say no, give this accommodation, or we may need to walk with you the next 2 weeks. But again, those phone calls, 10 minutes at a time, even if you end up having to pay outside the CRA, are extremely important and save thousands of dollars in exposure and attorney's fees after the fact.
Yeah.
If you use an unpaid leave for the reasonable accommodation and you don't have a position for them when you get back, is that a voluntary termination, involuntary? How does that work?
It could end up as an involuntary termination. It's a discussion.
Okay.
I would want to have a discussion. What else can we do? Can we slide them in for a part-time shift? Can we put them in 2 shifts? When is our next opening coming up?
So you're not done.
It could be a termination event,
Okay.
but I can also tell you in the hundreds, if not thousands of employees that I've advised be put on unpaid leave as an accommodation, 2 have come back.
Okay.
Maybe. And it's just something that over time, it's whether they actually needed the accommodation and whether they need the job as well, or whether they want the job.
For some, and this is probably for the FMLA, but we have a girl who's pregnant. We're seasonal because we're up in the mountains. She's having the baby in September and then wants to take 6 months off and come back in February. But obviously that's dead through our season. Do I have to hold the spot for her? I mean, I'm going to do the best I can anyways because she's been with us. Or, I mean, if she's waiting 6 months.
If she's FMLA eligible, she'll have that. That's job protected.
Okay.
In pregnancy, and it depends on what she's eligible for, I can tell you the family leave provisions almost provide a doubling of FMLA in the pregnancy circumstance, depending on the timing, depending on what she's eligible for. I'd want to have the discussion. But if she goes on FMLA and then family leave because she's no longer eligible for FMLA, technically her job is not protected on that second 3 months of just family leave.
Okay.
But it's and again, if it's unprotected and it's essentially an accommodation point, then you don't have to reinstate her at the end. But I'd still have her out the whole time. She'll be getting paid for part of it through family, and then have the discussion point at the end. The other part, to expand on that, the other big question we get is, what do we do with insurance during that time if they're on unpaid leave or on family FMLA? If you're paying a portion, look at your plans. Technically, you can have the employee pay their portion if they're not working. But generally, if you're paying half, at least, I have employers take an economic look at whether it's worth it for 3 months to pay the other part, especially if they're not getting COBRA, especially if they're not getting family payments. That's a discussion for an attorney before you just cut someone's benefits, because the easiest headline, especially in the bolder newspapers, is someone's fired on leave, or someone was fired during leave or while they were on pregnancy leave. Those are the toughest ones to deal with, just because, again, you're fighting to argue your case even though you're not guilty. Having fun yet? You want to take this?
Sure. So all of you, I'm guessing, are familiar with the comps orders. And I'm guessing you're all familiar with the fact that those seem to change at least yearly, if not more frequently. So the comps orders, the most recent one that was effective in January of 2025 includes an increased minimum wage, increased salary for salaried workers as well. The definition of a compensable time and hours worked, that's increasingly getting harder to figure out. I think I was just telling someone right before this presentation, I have a CDLE case where they're asking me to provide a calculation of time that it took from the employee to get from the parking lot to his work site. that's not compensable time under any definition. But when I have the CDLE investigators asking me questions like that, it's concerning. And so, figuring out where compensable time starts is a really important thing for all of you to look into. Again, we've already talked a little bit about the litigation with rest breaks and to a lesser extent meal breaks. I can tell you that's what I do a lot of. Micah and I spend a lot of our time on these rest break class actions. And so really making sure that you dial in those policies and talk to us if necessary about that is going to help you a lot. One of the open questions is what the statute of limitations would be that applies to that. That's before the Colorado Supreme Court right now. Right now it's 6 years. And as you all know, you're only required to keep records for 3 years. So, hopefully the Supreme Court will do employers a solid with that one, but it still remains to be seen. So there's a listing of some of the info sheets that you can take a look at. I encourage you, I look at them all the time. Obviously, this is what I do for a living, but I encourage you all to take a look at them too. There's a lot of information in there, and they slip new things in there a lot, and they pull the old ones out. And so, that can certainly help keep you in compliance. And then, obviously, we're here to answer any other questions.
So are you now recommending that people keep records for 6 years instead of 3, or what's your recommendation?
Keep them for free and ditch them.
Yeah, keep them for 3 years.
As you can.
Well, so the Court of Appeals ruled that it has to do specifically with minimum wage claims, that the claims under the Minimum Wage Act are subject to a 6-year statute of limitations versus a 3-year statute of limitations, which is true for every other wage claim, or 2 years and then 3 years if it's willful. And also it happens to coincide with the record keeping requirement. At this point, it is not our advice to have employers keep records for longer. I'm hoping that we get a decision from the Supreme Court here in the summer sometime on this issue, but it's one we've been waiting for. Our firm submitted an amicus brief on the issue. Obviously, it's our position that it's only fair that if you're only required to keep records for 3 years, you can only be subject to liability for 3 years. So, as I'm sure you're all aware, there have been some increases in minimum wage, both under Colorado law and in various jurisdictions. This is a tricky thing, and I can tell you from more colleagues' experience than mine that in particular, the city and county of Denver enforcement, they kind of just make up whatever penalties they want. And they can be onerous. So, making sure that you are paying the correct minimum wage for the jurisdiction and make sure to check it yearly. The thing I think is interesting about Edgewater is, from at least last time I checked, there's no definition of exactly whether you're in Edgewater. So that can be sort of, I think that's sort of interesting. I think there's maps you can look up for all of the other jurisdictions to see if you fall within their borders, but not Edgewater. So if you're anywhere near Edgewater, just be advised. So yeah, this is kind of what I was talking about with the Denver city auditor. Micah might know a little bit more about this particular case, but you've probably all heard of Urban Peak. They provide services for teenagers experiencing homelessness. They're a great organization. Todd Fredrickson is still very deeply involved, and even an organization like that is not immune. So certainly, as a restaurant, you're not either.
And specifically, this is a youth homeless shelter where they took $2 million in donations. This is a donation-only organization that was building a youth homeless shelter. And the city auditor's office, which is the third, we have the federal audits that people are receiving, the Colorado Department of Labor Division Standards and Statistics audits, and now the Denver auditor's office has been empowered by city council to not only engage in minimum wage investigations, but to subpoena records, etc. Mm-hmm. And this is what they're going after. They're making up claims. The head of the auditor's department is a law school professor who has zero legal actual experience, and he is coming up with claims that he theoretically believes are correct and then pushing them through because he's the judge, jury, and executioner. We just saw in a different industry in terms of downtown, the group of adult entertainment establishments nearby is suing the city auditor's office because they just got fined $14 million by the city auditor's office, where the city auditor admitted there was never a complaint by any employee. They just thought and were giving a parent or whatever they call it, a parental view from the government's perspective of the operations. So they can start these audits without any employees ever complaining. And that's the scary part. If they're willing to go after them, they're more than willing to go after you guys.
Right. So this is also something that's pending before the legislature to make some changes to some of this. But so the most recent change to the law with respect to penalties under the Colorado Wage Act is that you're liable for 2 times the amount of unpaid wages or $1,000 if you fail to pay all past due wages within 14 days. I can tell you this is a mechanism we use a lot, and whenever we get demands to, if you get a claim, and I got one last week that I think was like $3,000. It made more sense to pay that $3,000 claim than to get rid of any further liability with respect to any of these penalties, which can get really onerous. Plus attorney's fees if there's an attorney involved. It may make more sense to just pay it. So anytime you get a demand, make sure that you look at it and get it to HR, get it to counsel promptly so that we can take advantage of these things and try to cut off any liability that you might have. When I was mentioning that this is pending before the legislature, that 14-day penalty provision, they're trying to get rid of that, or 14-day, I guess fail-safe if you want to call it. And so, it remains to be seen what will happen, but that's a hugely advantageous thing for you to be able to take advantage of. And like I said, if it's found to be that it's willful, and pretty much everything is going to be found to be willful, then it's 3 years. But again, you get out of those penalties if you pay within 14 days. So if you pay within 14 days, as happens a lot in the cases that we have, there are employees that say, nope, that's not the right amount. I'm owed more. I worked more overtime than that, even though your records don't reflect it, whatever it is. And the standard is that, if on a good faith basis that you pay the amount that is undisputedly owed, then if they move on and they don't collect more, then you're entitled to potentially get attorney's fees. That's another thing they're trying to remove in this recent legislation that's been introduced. So it also remains to be seen what happens there. And there's also no definition as far as good faith basis. But anyway, this is always anytime you get a demand for wages, it's always a great time to get counsel involved immediately and, hopefully save you from potentially even a class action. So I'm sure you've all heard of the Power Act. So this came along a couple of years ago. So a few new things just to highlight from the Power Act. So it replaces the harassment definition, which used to be harassment needed to be severe and pervasive in order to be actionable. And it changes that to just any unwelcome physical or verbal conduct. So that's different than federal law. And it replaces that severe and pervasive, which was a higher standard than this new unwelcome physical or verbal contact.
Essentially, with our new generation of employees, it's whatever they determine is unwelcome. So it's not the severe and pervasive standard that has been around for 50 to 70 years is would an objective individual or person in the community find whatever happened, the name calling, the verbal reprimand to be severe and pervasive? Generally, even there are federal case law that says even if you use very, very derogatory terms that are not in any way acceptable, that's not severe and pervasive, even if it happens on a couple occasions. In Colorado now, if the individual person finds it unwelcome, that can be a standard for harassment. And in the generation that's coming up, everything is unwelcome in terms of any constructive feedback. So we're seeing more and more cases where I'm being harassed by my manager for being told to do my job. Yeah,
that's absolutely true. And because all of this is so new, did you have a question? Okay. Because all of this is so new, the Court of Appeals hasn't really had much of an opportunity to review it. And so, the exact parameters of what this is going to look like is still unknown. But one of the best things that you could do is to make sure that you've got a program that is reasonably designed to prevent harassment, deter future harassers, and protect employees from harassment. So a good, strong handbook policy that provides for what is considered harassment, what the investigation procedure is, what the reporting procedure is, et cetera. So, as always, at least on a yearly basis, it's a good idea to review your handbook and just make sure that you've got that in there. With respect to disability discrimination, so you can no longer avoid liability even if the disability has a significant impact on the job. So this kind of goes back to what we were talking about before when it comes to reasonable accommodation. You're never going to get yourself in trouble by looking into it and entering into that process. By talking with the employee and just seeing if there's a way that you can accommodate them. You're never going to get in trouble by going through that process. The biggest way you get in trouble is by not starting that process at all. So some other issues with the Power Act, it now protects marital status as a protected category in Colorado, adding to the others, which you're all probably familiar with, including some of the ones that are under federal law and also the additional ones that Colorado law provides. For non-disclosure provisions, so this also exempts any sort of non-disclosure provision that would prevent an employee from discussing alleged discriminatory or unfair employment practices. So that's a tricky thing. Essentially, you cannot prohibit an employee from discussing what they believe in good faith is discriminatory or harassing, from discussing the facts of it. And obviously, there's a line at which it's no longer true, but it presents an issue with employers who I think in the past have been able to resolve claims and have complete non-disclosure. You want to talk about this one, the record keeping?
The record, yes.
Yeah.
So record keeping. So this is an interesting update in terms of what the Power Act actually is required. So employment records, time records, still 3 years. There is a caveat to the Power Act that requires you to maintain employment or personnel records for 5 years. What they're going for is investigative records. So generally, if you have a personnel file, which a personnel file is defined by statute, is generally just hiring, firing paperwork, promotional opportunities, etc. I generally advise that any investigations or those types of notes or the follow-up are not parts of a personnel record. So I'm sure all of you have received a letter from a former employee saying, hey, can I have my personnel records? You should just be sending the baseline statutory required paperwork. With respect to if you do have investigative paperwork that you maintain in a separate file with respect to employee complaints, harassment, etc., you do need to keep those for 5 years now. We haven't seen this come up, obviously, because the Power Act is still new. But I anticipate in 2.5 years that we're going to start to see issues with this come up where employees don't have these records or haven't maintained any investigative records, and the plaintiff's bar is going to try and use that against employers. So this is a long game for the plaintiff's bar and for the legislature, but it's something to keep in mind. If you have an HR file for investigations, etc., put the ticker to 5 years instead of 3 now. And maintain those in the event that it ever comes up. And you could be in a circumstance where you don't have the employee's time or pay records in 4 years and you have one investigative paperwork. That's what's required. It doesn't make any sense. This is their attempt to expand it. I don't know why it's 5 years. It doesn't make sense compared to any other law, but it's something to keep in mind to the extent your HR has those types of files. Oh. Okay. I'm sure everybody loves Healthy Family Workplace Act. I'm sure all of your employees have used it to their advantage at certain times over the years. At this point, there was an update 2 years ago with respect to the definition of what employees can go on sick leave for. At this point, I tell employers, if your employee's dog's cousin's sister is sick, they're probably going to get sick leave. If you have employees asking for sick leave, and they have it available, it is very hard, and I haven't come across a circumstance where you can catch the employee yet. The state has made it very easy for them to use this time. We have to provide it. My advice generally is burn it. As soon as they take it, burn it. If it's after 4 days, ask for paperwork, go from there. Follow your policies after that. But the state has allowed employees basically an extra month of leave, paid leave by you during the year. So make tracking it, burning it, And when employees run out, they're out. And if they're out of leave, if they're out of any other type of accommodation or leave, then your disciplinary process steps back in. But be very careful with sick leave, track it, burn it as soon as you can. But this is an issue where it's really hard to defend any termination of employee on sick leave or for taking sick leave. Because the retaliation provision now goes back to the Power Act, it's a high bar for an employer to show. And outside of some very discrete acts during on sick leave or something you find out with hard evidence, again, I haven't seen the silver bullet yet to beat sick leave. So tracking and burning it as quickly as possible is important.
And the other thing I would add is that this is another place where it's a good idea to take a look at your handbooks. This last, the end of the year, we always have a cycle of people wanting to update their handbooks. And this last cycle, what I saw on more than one occasion was policies that provided for asking for a doctor's note early than the Healthy Families and Workplaces Act provides. And that can get you in trouble. So, just, again, it's a good idea to take a look at it and get HR and counsel involved.
So these expand, documentation, documenting the 4 days is extremely important. We have employers who let employees out till 6 or 7 days and then are not tracking it. They don't know. Making sure you're tracking the days, how many consecutive, if it's 4 consecutive, ask for the note. Family leave is an interesting, obviously, I hope all of you are paying in. I did have an employer yesterday who wasn't paying in, which was an interesting update. They didn't have many Colorado employees. They had no idea about the law. My hope is that you've all got this set up. Is anybody on a private plan? Okay, and it's been approved, etc. That's great. We are seeing more private plans. We're seeing more QSR groups or franchisee groups get together and put together private plans to avoid family leave. This is a very technical undertaking. If you are interested in that, or if your HR or your ownership group are interested in that, we're happy to talk. And by that, I mean, I have a benefits expert down the hall because I have no idea how to set this up. But Ron is an absolute savant at it and can help you and has set up and worked with the state to set these up if you want out of the family leave program. It's been interesting to hear that we're hearing only about 30% of family leave is being used. So this program isn't being used, not just in this industry, across the board. So it isn't being used as much as I think the state thought it would be, because employees don't want 2/3 money. Some employees want to get paid to not work. That's not the majority of your employees, which honestly, it gives me a little bit more faith in society in this state. This chart, again, as we've gone through this presentation, I've started thinking that in addition to our handbooks and everything else, I think we may want to start posting all the info sheets on the website. I'll talk to Sonia about that because they do change all the time. They usually change when we beat the CDLE.
Yes.
Hillary beat the CDLE. One example is for those of you that have bonus programs, which isn't as prevalent in the industry, Colorado now takes the position that you can't have a policy where bonuses, you have to be employed to receive your bonus. It's a big issue that we're seeing in other industries right now. If you have bonus programs where you don't pay the bonus out to employees, where I see this in your industry is people who pre-schedule parties and you get a percentage of that party when it occurs. If that person's terminated before the party, the question is, do they still get the bonus? The Colorado Department of Labor is going to take the position they do because it was pre-scheduled. There's a set number. There's nothing else to be calculated until that date. They're telling employers, you have to pay that bonus after the employee leaves. Hillary won the first case against the Colorado Department of Labor on this issue, and they changed the info sheet a week later. So that's what they do. They did the same thing to us when we beat them with respect to unionization. They changed the info sheet completely. So be ready for that, but we'll talk to CRA about that. I say that because this is it's part of an info sheet online at the CDLE, and it's important if you have people on family leave. Equal Pay for Equal Work Act, job postings. If you have questions about job postings, the easiest advice I can give, because the question that comes up the most is promotions. If you have a new position that you're interviewing for, and it could be a promotional opportunity for anybody in your restaurant. If it's an assistant manager level position that you're opening up, you have to provide at least a posting or notice to all your employees, your line level employees. If it is a position where you're promoting a server to a manager, You do not have to post that. That's a progression of employment. That's a promotion. They're being promoted to a single role. But if you're opening a position for applicants, it needs to be posted and noticed to all the employees that you have that could see that as a promotional opportunity. This is a silly one. A couple or 5-6 years ago, we had the ban the box law where we all changed our applications. Your initial application form to not include any box with respect to felonies, arrests. We need to go back to our application forms and make sure there isn't anything that identifies employees' age, whether it's a graduation date, a birth date, etc., unless it's specifically necessary. In our industry, it is 1821, but I would recommend having that on a second application page. Your initial application, whether it's on Monster, you post it somewhere, don't have anything age-related. Ask on the second question. When you send a questionnaire, etc., do you qualify? It's the easiest way to avoid liability here. It's not a toothless law. It's similar to ban the box. All it applies to is the initial application form. After that, you can ask age, etc. But go through and check and make sure if you have external recruiters posting your positions that they are updating their postings as well. Unemployment notice. I hope, how many of you are handing out unemployment notices to all employees leaving? That'll get sent out. Anytime an employee leaves, quitting, fired, etc., you have to send one piece of paper. It's state regulated. It's simple. You just have to send it with them with a COBRA or whatever notice. But no, if you don't have this, reach out to CRA. I'm just going to send it and they can post it in the resource center.
Yeah, fortunately, it's a very simple form, but so it's an easy thing to comply with.
We talked about Pregnancy Workers Fairness Act. Again, anytime you have an employee who is about to go on leave or has noticed that they're pregnant, again, having the accommodation discussion then early and when they're about to go on leave is important. They may need accommodations before they go on leave. And that is extremely helpful to know up front. But under the Pregnancy Workers Fairness Act, both the federal and the state level, there's exposure for not following through on those accommodation discussions. Mm-hmm. Unions. We've had more union calls in the last 2 weeks, unfortunately. We continue to see unions attempt to organize in restaurants. I hope that this calms down in the next 4 years. The NLRB right now has its own issues federally, and the state obviously is pushing through its Labor Peace Act changes. But my hope is that this industry continues to be not impacted in Colorado the next couple of years. I think we're still safe to a point, but if you have any unionization calls, if you have employees talking about unions, or if you see cards, call. It's a very discrete part of the law. There are a lot of protections for employees in terms of what they can say and what you can say. I do 2 to 3 hour presentations on NLRB compliance, especially in restaurants and other industries. So if you start to hear any rumblings, call immediately. It's important because the last administration federally allowed unions a little bit more leeway in terms of what they're able to do in the rules. That hasn't been entirely rolled back. And it's, again, unions can essentially say and do what they want, employers can't. But to the extent you have questions, call. Because what I'll probably do is have your managers run through, I call it tips training for an hour, so they have a list of things they can say and respond with. But it's an important thing to know and not to look over, because as you've seen in our industry and in the CRA, unfortunately, when restaurants get unionized, they generally close within a year. Why workers turn to unions? I'll give one tidbit on why, or the best way to avoid it. All of us are busy. The easiest way to lose your employee group is to not respond to questions, or your managers don't bring you questions that are asked. Everyone's busy, but when your manager has an employee ask a question and doesn't get back to them, or doesn't say, hey, I'll get back to you, and come back with, hey, I don't know, let's wait. That's the easiest way to get a union in there. That doesn't just apply to this industry, it applies across the board. But reminding your managers, hey, you're our front line of defense. Your managers can get you an exposure without you ever knowing the conversation or the text messages that are going on. And the text messages, especially in this context, can be very important. So reminding your managers, hey, you're the front face of the company. You're an exposure level person. You need to, when you have communication with employees, you need to make sure they're professional. Make sure that you are representing the company, even in your text messages. And that is in this industry where I see the biggest issues. Managers texting employees, the text change go into other things, or they're not the most professional responses. It's hard. It's tiring. Reminding them, hey, if you're communicating, let's just up the game a little. Let's be like, if you're doing an employee text message, make it read like an email. It's hard. And I'm going to tell you, your managers are going to scoff at it and laugh. If you can enforce this though, or kind of push it, it can avoid a ton of issues that in other cases that we're winning can cause us to lose. I've had text messages come in from managers where it's a, oh God moment for us. Even though we thought we had a completely defensible case, one text message from a manager that says something really stupid, can open up the entire bucket. Why unions organize? They're not 501c. They're companies. They make money off your employees. Your employee size groups, regardless, are just ticks on the dog's tail. They want their employees. They want the dues. They're never going to care about your employees. They're going to care about UPS and Greif and all the big Safeway. They're just going to get yours and their dues and ditch you. So if that comes up, let us know. We have a labor team. Tammy Kolker is a partner in our office who is the head of our national construction group and a preeminent labor expert. She's also a killer. If you need training or you need people to deal with unions, she is the number one person now that Todd is retired to go to with these issues. I'm going to skip. State level investigations. If you get an audit letter, call immediately. You usually have 2 to 3 weeks to respond. But these are happening on a more frequent basis and you're seeing them from 3 levels. So if it's federal, we can take a breath and know where we're going through. I have a checklist after about 1,000 DOL audits that I know basically every question they're going to ask and we can prep your team. The state level and the city level ones are scary and we should be hands-on immediately. This is the whole team. Sarah wasn't able to make it, but again, Sarah, another Colorado native who's worked at Colorado restaurants, who just moved back from California. So again, any questions you have, if I'm busy or if Hillary's busy, we've built a team for the CRA specifically because the amount of lawsuits coming out and being able to defend, I think are important. One other thing I'll say, just because handbooks, we have a deal with the CRA. If you need a handbook review, it's easy. It's a set price, and I'll tell you in 5 minutes when I look at your handbook whether I'm going to give you a template one that's bulletproof or I'm going to edit yours. The other one is arbitration agreements. They can be part of the handbook packet. What they are is individual agreements with every employee that if they have an issue and they're going to sue you, they're going to do it individually and they're never going to have a class action. So all those class action numbers, if the employer is what we're seeing now, and we just won a case and we're at the 10th Circuit where an employer had started arbitration agreements 3 years ago. Mm-hmm. And there was an employee from right at 3 years ago who sued for a class action. They demanded $12 million. It was mileage and rest breaks. The court dismissed the case outright because the rest of the class had arbitration agreements and that employee couldn't represent the class. And if it's an individual employee with an arbitration agreement, they can't even bring a class action. So they're extremely important. If you have questions about them, we're happy to discuss them. But in terms of at your levels for single site owners or even restaurants that have 10 to 20, is more locations you have, the more important they are. But even at single site restaurants, they're very important to avoid one bad apple working for you for how long did he work? 2 weeks?
I think a whole month.
He went to this employer, worked for a month and then sued. It's what he does. So avoiding these people who are out there, is a big thing.
And I would encourage even smaller restaurants to look into this because you may think I don't have that many people. Like how am I going to get a class action? There's no set number on how many people can be in a class. But it starts at around 40. And, given that you're looking back 3 or maybe 6 years, that can be a pretty sizable group of people.
And 100-person class for rest breaks would be at least 260 to 420,000, depending on how much you're paying. Questions?
One in the back.
That illustration probably earlier about the rock in a hard place probably reflects how a lot of people in the room feel right now. Is there anything as owners and operators we could do to protect ourselves with the changing laws from an insurance standpoint, like a EPLI coverage or anything of that effect? Because I would say a majority of us, all of us, are hardworking people that want to follow the laws, but the laws are just changing way too fast.
So EPLI insurance is important. If you have EPLI insurance, what I can tell you is, one, if you don't have it, look into it. There are 100 different types of coverages you can have. The majority of coverages we see cover all discrimination, retaliation claims entirely. They'll pay your defense costs for attorneys, and they'll pay a settlement. Wage and hour, we've seen recently an uptick in insurance coverage for at least attorney's fees. They're never going to cover the exposure of the settlements because you see the numbers that come with it. But EPLI is important. We work with a lot of adjusters. The question you want to ask your insurance agent or adjuster is selection of counsel. And I'm going to walk very carefully through the next minute because I have to be very careful. We have seen an uptick in cases in the restaurant industry specifically where you have an EPLI coverage and EPLI coverage picks your attorneys. The issue with that is EPLI's agreements with the law firms are not with employment law firms. They're with car accident firms. The majority of class actions that have been certified in Colorado are defended by insurance defense firms who primarily do car accidents and have never done employment cases. So when you have an EPLI coverage, make sure that you have a selection of counsel clause where you can pick whether it's Fisher Phillips, whether it's one of our cousins who does just employment law. This isn't rocket science, but you pay us for the 10% everybody doesn't know. Or you want someone who knows those 10% of issues, and those aren't the firms that EPLI are going to pick at the lowest rate. So the biggest part of EPLI I've seen in Colorado, and we've fought coverages on, is selection of counsel, because coverage is great, but if your insurance company is only going to pay so-and-so law firm to do an employment case on the side of their car accidents, it actually creates bigger problems. We have 3 class actions where insurance defense firms have blown over $250,000 in fees and done nothing in the case. They haven't defended it. They've never taken a deposition of plaintiff. They're 3 to 4 years in the case and have not done much. The employer runs out of insurance coverage and then is stuck. So it's important to have, if you have EPLI, make sure that you have the choice of, let me at least select 2 law firms for options and not just be stuck with what EPLI covers. That's a great question.
Well, so none of the EPLI affiliates out there cover settlements?
No, generally, they won't cover wage and hour settlements. Some do. There's some policies that will. They'll generally always cover a retaliation settlement or a discrimination claim. Most of the coverages we're seeing will only cover defense fees for wage and hour. But again, defense fees for a wage and hour class action, even at insurance rates. So even when you get a Chubb rate, which is probably less than half of my daily rate, which we still will do because that's how important these cases are, it's still $250,000 in defense easy, even if we're running. But having insurance cover that part at least allows you to know where your options are if you have to settle.
I'm so sorry. There is so much to discuss in this topic. It's not even funny. It's a little scary. And thank you all for staying a little late. I appreciate it. Thank you to Micah and Hillary. Thank you to Maggie from Toast for your support. I know that these guys will be around. Micah and Hillary will be around, so you can keep asking questions. These slides and this recording will be sent to all of you who have education passes. If you don't, just get in touch with us, info@corestaurant.org, and we will help you. And a lot of the resources Micah mentioned are also in our compliance center.